I hope everybody can hear. If there are any issues, you can quickly post something through the Q&A, but I'm sure we're all Zoom experts by now and everything should be running smoothly. Thank you for joining us this afternoon. Welcome to the Queenstown Chamber of Commerce Westpac NZ webinar series, something that we kicked off in lockdown, and the technology is as useful today as it was then. We're very pleased to have with us today Privacy Commissioner John Edwards. This Zoom really is a replacement of a workshop that John was going to run here in Queenstown a few weeks ago, and not only do we have our challenges these days with COVID disruptions, but one of our old school challenges of a snow day interrupted that particular session. So very pleased to have John with us. He's going to talk to us about the new Privacy Act, which comes into effect very soon, 1st of December. I won't steal any of John's thunder about what this Act is about and what it's trying to achieve. But other than to introduce John, he's been Privacy Commissioner now, I think, for almost 7 years for New Zealand. From a legal background, chaired the New Zealand Law Society and the Privacy and Human Rights Committee, and contributing editor of Brokers Human Rights Law and Practice. So obviously highly skilled subject matter expert and somebody we can all learn from. So John's going to give us about 45 minutes, and then we'll have about 15 minutes of Q&A at the end. We will be recording this session and we'll make that available to the Chamber members tomorrow for those that need to catch up if you have to duck out early or if there's anything you want to cover again. So I will hand over to John, and over to you, John.
Kia ora koutou katoa. Thanks, Craig, and thanks to the Queenstown Chambers of Commerce and Westpac for facilitating this. It was a shame that I wasn't able to come, particularly because I'd only had a couple of days skiing in Queenstown this year, and I was looking forward to perhaps taking a day onto my visit a few weeks ago. That was not to be. Richly ironic that I was kept out by snow. I will be coming back to Queenstown, which is one of my favourite places in the country, on the 17th of November. So I'm sure we'll have some public events. If we can't get to your question today, hopefully we'll be able to meet up again and cover it off then. I'm just going to, oh no, it says host has disabled participant screen sharing. So I don't know, Fiona, if you could maybe
job for me.
Fix that.
There we go. All should be good to go now.
Okay. And here we go, preparing for the Privacy Act 2020. I mean, I usually like to just start with a few introductory remarks. You know, in the time that I've been working in this field, which is coming up for 30 years, I have to say, I've many times seen these proclamations about the death of privacy, often in the media, often associated with the advent of some new technology that makes novel use of personal information. And very often uttered by someone in whose interest it is to be so. Privacy is not dead. Privacy continues. It's in my interest to say that, of course. It's my job to say that. But we find that that assertion that privacy is not dead is backed up by our empirical evidence. We do a UMR survey every couple of years and just track the levels of concern in the community. And we find that there is an increasing trend towards greater concern about businesses' ability to protect personal information and the effect that that has on the individual privacy of citizens. What that translates to is you know, a value that's really important to the people who pay you money, they make up your business, and for whom you provide goods and services. So it's in your own interest to ensure that you take good care of the personal information which is entrusted to you. Now, I know you all want to hear about the Privacy Act 2020, but before we do that, I think it's helpful to just have a quick refresher on what the 1993 Act had in it. I know you're all very interested, and I very much appreciate your interest, and it's great that you've come along. I don't like to assume that you are as familiar with the law as I am. Me and my team spend all day, every day looking at privacy. You have a whole lot of other things on your plate, especially in this COVID time. You're dealing with health and safety and employment. You're dealing with the Employment Relations Act, Commerce Act, COVID stuff. And, you know, I don't expect you to be experts. So any questions that you have, please feel uninhibited. I'm happy to talk about first principles, not just the small changes, the modest changes that are coming with the Privacy Act 2020. So to understand how the Privacy Act works, I want you to just think about a couple of foundational terms. First one is agency. That is the term that describes the entities that have legal responsibilities under this law. An agency is defined in the Act as a person or body of persons, whether corporate or unincorporate. And then it just goes on to list some exceptions. So not included in that definition is the news media in relation to their news gathering activities, the courts in relation to their judicial functions, members of parliament, and the Governor General is not subject to the Privacy Act. But if you take them out and look around the community and the economy, it's a hell of a diversity, right? So the ski field is an agency, the church is an agency, the music teacher, the babysitter, the insurance company, the chemist. These are all entities to which the Privacy Act applies. So the second term I want you to think about is the personal information, which is the currency of the Privacy Act. That term, personal information, is defined as information about an identifiable individual. Not private information or sensitive information or secret information or intimate. It's just if it's about an identifiable individual, it's covered. So when you put those two things together, you see the work that this law has to do. It covers the entire economy in relation to an infinite number of variables and different kinds of information transactions. Now, in that scenario where you have to have one law dealing with such variety, you've got a couple of choices to make. You can have a very prescriptive law that tells you, sorry, I was just checking the Q&A to see whether there was a problem with reception or anything. Seems not. It's a substantive question. But, you know, a law which is certain and tells you everything that you have to do in every situation. You know, you're in downtown Queenstown, you can only drive 30 kilometers an hour, not 35 or 40 or 50. And when you're on the open road, you can only, you know, if you're going out to the airport, what is it, 80? Anyway, my point is, there are some scenarios where you can regulate very prescriptively and leave no one in any doubt about what side of the law they're on. The Privacy Act doesn't really lend itself to that, this infinite variety that I was describing. So what it does instead is it sets out a set of principles, a best practice, and they're intended to guide agencies to treat information appropriately through the whole life cycle of that information through their organization. So I want to just take you back to those principles. We got them in 1993 from a 1980 OECD report. And many countries, most of the countries that we trade with, have privacy or data protection laws that are based in that same DNA of that OECD report. And you'll see variations of these principles all around the world. So the first four are about collection. And the first one is what my colleagues in Europe call the data minimization principle. If you don't need it, don't collect it, right? Simple. I actually called out one of your principal tourist industries, enterprises on this a few years ago. I was signing up for my pass at Cadrona or Coronet, I can't remember which it was, and and it said name, date of birth, address, gender, male, female. I had to choose. And I said, why do you need to know my gender? Anyway, this was an exchange that happened on Twitter. They came back and said, well, so we can identify you, prevent fraud. Okay, legit answer, but really, have you seen what people wear on these ski fields? Anyway, my point is, you really have to interrogate your information needs and make sure that you're satisfied. You're only collecting the minimum that you need to achieve your legitimate business objectives. Where you can, get it directly from the individual. That one, it doesn't work as an absolute rule. None of us can get through a day without breaching that one, but that's okay. It's got exceptions in it, which say, if no one's going to be harmed by it, you can get it from someone else. Be open about what you're going to do with it. Tell people why. This is one of the really important ones. Be transparent. If one ski field or bungee jumping firm is going to collect a whole lot of information, there's nothing in the Privacy Act to prevent them as long as they tell me. And then I can make a choice and I can say, okay, well, I'm going to ski Remarkables today because I don't like the way Coronet collects its personal information or something like that, right? So that is as a business, it's your opportunity to write your own Privacy Act as well. It's about your policies rather than something that's imposed upon you. The fourth one says, don't collect personal information by means that are unlawful or unfair or that intrude to an unreasonable extent on the personal affairs of the individual. Okay, so that's the first four, collecting. Once you've got it, keep it secure. Now we're going to come back to that one because it's a very general principle. It does a lot of work. 6, everybody has a right of access to their own information. And we often don't recognize that as a privacy value. We think about privacy, we think about keeping things secret, right? But every single one of you is entitled to go to your bank or your doctor or your insurance company and say, give me everything you've got about me, or your employer for that matter, the school board, and say, what have you got about me? Show me the information. And there are a limited number of reasons for them to refuse to provide that. Once you've got that access, you're entitled to ask for that to be corrected if they've got something wrong. When you use your personal information, take reasonable steps to ensure it's complete, accurate, relevant, up-to-date, and not misleading. That's number 8. Don't keep it for longer than you need it, right? It's the flip side of principle 1, isn't it? Don't collect more than you need, get rid of it when you don't need it anymore. Only use the information for the purpose for which it was collected. But again, that's not very constraining because you've decided what those purposes are, you've communicated them to the individual, and so you're only limiting yourself to a certain degree. And don't give it to other people unless you need to for the purposes for which it was collected, or one of the other exceptions applies, and I can come back to those. We've got a new principle, and I'm going to come back to that. It's about the export of information, sending personal information overseas. The old principle 12 has been bumped up to 13, and that's about the use of unique identifiers. And I never like to spend too much time talking about that. It's a bit boring, unlike all the other really fascinating stuff that we're talking about. So that's the framework. The Law Commission examined it extensively from 2006 to about 2011, wrote these lengthy reports, and concluded after that close scrutiny that the fundamentals of the Privacy Act are pretty sound. They work well. The regulatory model seems light-handed, but it's effective. The principle-based approach is sound, and we should maintain those. But they said there are a few things that need a bit of modernizing. It needs to be refreshed. This is, remember, back in 2011. In 2014, the government at the time responded to the Law Commission's recommendations and said, here's what we're going to do. And we'll have a new Privacy Act with more modernized drafting, and we're going to refresh some of the policy content as well. And I'll take you through that. But it took until 2018 actually, before the privacy bill was introduced. The last government got a bit snarled up with it, and it was this government that, well, sorry, I guess we are the last government. Anyway, whatever that multi-headed thing was that we had last time, the Labour-led coalition got the legislation into Parliament and passed earlier this year, and it will now come into force on the 1st of December. What's in it? Let's see. The major new obligation on business that you'll need to be conscious of is the top line there, mandatory breach notification. I already mentioned that one of those principles, Principle 5, requires that you keep personal information safe and secure. But there's no real sanction for that. It's often not well understood that I, as Privacy Commissioner, don't really have very much power to enforce this law. And there aren't really penalties for breaching it. You know, I'm often getting calls from journalists and the like saying, oh, did so-and-so break the law, and what are you going to do about it, and what's the punishment going to be? Well, you know, very often there's not really any sanction. So that's going to change a little bit. If you breach the obligation to keep information secure in a way that could cause serious harm to the individuals concerned, you will have an obligation to notify them and to notify my office. That's mandatory breach notification. The rationale is it was your job to keep it safe on behalf of those individuals. If you failed in that, you have to hand that control to them so they can change their username and password, so they can cut up their credit card or renew their identity document, that kind of thing. And you have to tell me so that I can figure out whether I need to take some further action or whether I need to communicate out to the wider world what your experience was, so other people can avoid that problem that you've had that led to the leakage or loss of personal information. So that's that. There's a threshold. It's the obligation to notify arises when the breach could cause serious harm. And if you fail to notify me of a breach that you ought to have, you can be fined up to $10,000. So that's, again, getting a little bit more muscular in that sanctions space. And so it's the next one. You know, I have had no power to enforce the Act. You might know that my colleagues in Europe get to issue fines of 20 million euros. My UK colleague has just issued one of 20 million euros. They can issue fines of 4% of global turnover or 20 million euros, whichever is the greater. In the US, the Federal Trade Commission, which has similar functions to those that I have in this space, they issued a fine of $5 billion to Facebook. So I went to tell the Minister of Justice about all of this, and he said, yep, well, that's all good. You can have compliance notices. You know, I've lost that scrap to have the really hefty regulatory tools, but we will be making the most of these compliance notices. If I see some practice or conduct which is in breach of the Act, clearly I can issue a notice requiring that stop. If I see someone not doing something which they ought to be doing, I can issue them with a notice requiring that they do it. And if they don't, then I can enforce that compliance notice in the Human Rights Review Tribunal and achieve a fine, a penalty of up to $10,000 again. There will be new criminal offences. It will be a criminal offence to respond to an access request, that's a request by the subject of the information, by destroying that information. That will be a criminal offence. It will also be a criminal offence to impersonate somebody else with the intention of accessing or altering their personal information. I will be able to make binding decisions on access requests. So again, that is going to assist people to exercise that right of access and truncate the process of enforcing that right that they have. There's a very long word in there, that bullet point under binding decision. It says extraterritoriality. What that means is our domestic law will quite explicitly apply to businesses and enterprises that are carrying on business in New Zealand, whether or not they have a legal presence here, or whether or not they have a bricks and mortar presence here, a physical presence, whether they have employees or servers, it won't matter. The test will be, are you carrying on business here? You know, are you collecting New Zealanders' personal information? Are you selling advertising, that sort of thing? You probably know who I'm talking about here. And so that's going to put those international digital enterprises on the same level playing field and regulatory playing field in New Zealand as domestic businesses. I mentioned the new privacy principle about the movement of personal information out of New Zealand. That principle says that there are sort of due diligence steps required. If you're going to send personal information to an agency that's not here, you've got to satisfy yourself that there's a comparable level of privacy protection in that destination jurisdiction. And if you can't do that, you either send it with model contractual clauses with your partner in the other jurisdiction to ensure that it's protected, or get the explicit consent of the individual subjects. There'll be lots of material on our website about how to do that. We've actually commissioned a major law firm, Chapman Tripp, to prepare those contractual clauses so you can use them with a travel agent that's based in Queensland, and we haven't assessed Australia's privacy law. You might just want to say, well, yeah, we'll exchange manifests and the like, but here's the model contract clauses which mean that the information will be kept safe. There are a couple more refusal grounds for refusing access to information where the disclosure would enable serious harassment of an individual or sort of re-victimizing of a victim. So that's what's new. Everything is new in the Privacy Act in one sense. It's redrafted. The Cabinet in 2014 not only said you can take these half a dozen new policy initiatives, but we'll rewrite the Privacy Act in more modern language. So it will look different. It'll be reordered. If you need to, if you are familiar with the 1993 Act and want to know what's where, we've done a comparative table that matches the provisions from 93 to 2020 and back. It's on our website, privacy.org.nz. So what we've been doing in 2020, like every other fall, we began the year with a plan. We were mostly focused on what we're calling Privacy 2.0, how we take the opportunity of new legislation to change the way we do what we do and become a more effective and modern regulator in a digital economy. And that's been interesting. I've been hiring new people and getting new business models and things. But we've been quite busy with COVID, and it's one of the unexpected side effects of the pandemic has been to significantly increase the information collections of ordinary businesses. Many of you will know that you've had to collect registers of people entering your premises when you never did before, and this is replicated up and down the country. So we've been trying to respond to some of those issues. I did an inquiry, some of you may know, into the Ministry of Health dissemination of COVID diagnostic information, and I want to share a story with you because it's from your region. Somebody wrote to me when she found out that I was doing this inquiry to talk about the personal impact of having been identified as COVID positive. It was very moving, and when we talk about the law and what we're doing with privacy, it can get a bit abstract, but we have to remember this is about human dignity and individual peace of mind. And the story is instructive in other ways as well. It tells us that we have to think very carefully in this new digital era of social media and the like about what information we share, and even if we think it's anonymous, can it be unpacked? So your good mayor was speaking to the DHB and was advised that there was a case of COVID in X town, and I won't identify the town, and he posted that on his Facebook page. That was fine, right? There's a case, it's in this town. That doesn't tell anybody anything, that's anonymous. It just gives us an indication that across Central Otago, here's the sort of distribution we're seeing. But the next week, the Ministry of Health publicly advised that the cluster that they were investigating was associated with the Hereford Breeders' Conference. Now, everyone in that region went, oh, X-Town, there's only one breeder there, so it must be them. And that's how they were identified. Now, they were very unwell and trying to recover, and at the same time they were being vilified on social media, ostracized from their community. When they recovered, they had to get permission from the local cop to drive 50 kilometers further to the next town to get their shopping, because when they went into their own town, everybody knew, and they were constantly being stopped or avoided, and it was really unpleasant. I mean, they did report they found pockets of really strong support in their community, but just the experience that comes with the fear and ignorance associated with a new illness in a situation like the pandemic, I thought it was quite revealing. I won't linger on this slide, but there may be other issues that we can usefully discuss. I wanted to just talk to you a little bit about privacy breaches. We've been running a mandatory reporting scheme for the last few years, and we're getting about 250 reports of breaches a year. I don't know whether all of those would reach the threshold of sort of possibly causing serious harm. But if our pattern follows that of Australia, when we move to a mandatory system, we'll probably see a 7-fold increase in reports. The idea of reporting to us as the central agency, rather than just to the affected individuals, is that it gives us information about where the kinds of problems are arising. And I wanted to share some of those with you today. Email is just a perennial problem. And if you want to do one thing, just have a look at your default settings in your company's email and what protections you could put in. Can you have a warning if someone is sending an email to more than 5 people? Can you color code the email addresses so that if it's an internal email, I don't know who's on this call, I'm sorry, but if you've got someone from the council, for example, all the .qldc .gov email addresses might show up in the light blue and external ones in black, so it really sticks out on that email address field. Are you sending spreadsheets around? If you're a manager and somebody sends you a spreadsheet with 3,000 customer details in it or patient details, you might just think, well, yeah, of course, there's no harm because I'm the manager, but I don't actually need that. And just having this stuff cross our network creates a risk. So, being alive to that kind of thing and conscious. And if something goes wrong, deal with it effectively. There was another issue that we came across with an email from a DHB that sent a spreadsheet of people who'd received bariatric surgery out to an unknown address. And they decided to do the right thing and notify the people who had been on that list, even though they weren't really sure if the email address they sent it to was live and the person was going to do anything with it. But they really kind of compounded the problem in the way they communicated with people. So they were well-intentioned, but they sort of botched their response, and that left some people feeling really quite hurt. So thinking about that is important. Employee browsing is the second big issue that we see on there. And employee browsing is when somebody with legitimate and authorized access to personal information in your organization uses that for inappropriate purposes, for their own personal edification. And I had someone, I was talking to a bank about this a little while ago, and they said, oh, we flag important accounts so that if somebody's going to look at John Key's banking records, they're going to get a phone call in about 2 minutes. My response to that is always, well, actually John Key is not going to be a big issue. It's somebody looking up the daughter's new boyfriend, right? Or the babysitter, or whatever, the person across the road, those kinds of things that you'll never pick up. So the best way of addressing employee browsing is fostering a culture of respect for personal information and making sure people are only using it for legitimate reasons. Second best is audit. If you've got access logs in your system, every now and then just go to someone in the organization and say, hey, I see you were looking at John Edwards's records the other day. What was that about? And, the answer doesn't really matter. They might say, look, I do coding. I code 200 things a day. I have no idea why I was looking at that. Sorry. Or yeah, he was standing right in front of me. Doesn't matter. What they remember is somebody noticed and they were asked to justify it. And that reinforces your message that this information is there only for legitimate purposes. Website errors, I've got some interesting examples, which I think, in the bottom right one there, the 28250, I've characterized as a problem with the kind of the retail nature of quite sophisticated technologies, you know, the kind of democratization of digital technologies. So everybody can start up a website. You could launch one this afternoon if you wanted to. In this case, it was the Ministry of Culture and Heritage. They launched a website to promote their Tuia 250 promotions and commemorative events of Cook's and first encounters with tangata whenua. And because it was just acting as a bulletin board, they just stood it up internally, you know, so with a bit of wherewithal, and they didn't go through the normal government procurement and security checking processes. And that was okay if it was just being used to notify people of, you know, the dates and places of events. As I say, just like a bulletin board. But then some months later, someone had the bright idea of running a competition and offering people a place on these waka to paddle. And you had to enter and you had to demonstrate your eligibility as a New Zealand citizen or person in New Zealand. And that's fine. The guy who did the website said, "Oh yeah, we can get a plug-in for that. I'll just stand up this WordPress edition," and we're away laughing. Well, a few months later, this person rang the Ministry of Culture and Heritage and said, "My son's driver's license has just been used in an attempt to fraudulently obtain credit. And the only place he's used that was on your website." So the ministry did a review of their security, and you'll be pleased to know they didn't find there was a security breach. Because in order for there to be a security breach, you've got to have security, right? In this case, the plugin that they'd used simply allowed the uploading of identity documents to this public-facing platform that was searchable with reference to any of the information in there, so name or whatever. So, it would be like just pasting it right on, lampposts around the waterfront in Queenstown. So that was pretty embarrassing and potentially very harmful. There were 300 passports, driver's licenses, even a couple of firearms licenses uploaded onto that site. The Ministry of Health one in the middle there is a situation where Tū Ora, the primary health organisation, they had their website defaced and there was no personal information implicated in that. But as a result of that attack, they did a security review. And when they did the security review, they found that this malware had been placed on their server some 18 months earlier. It created a vulnerability that could have led to the exfiltration of personal information, quite sensitive patient data. But they couldn't tell whether it had been exploited or not. What they did know is if they had patched the server software in the way recommended by the vendors, that would have been detected much earlier, and they could have been certain that there was no harm done. So that's quite an instructive thing. Don't skimp on your cyber security. What else have I got? We've just launched actually this tool to allow agencies to get some assistance in determining whether their experience constitutes a notifiable breach. Because I don't want you to tell me about every little near miss or close call or, Mavis rang the wrong number. We've designed a mechanism for you to add your information and then if it does meet the threshold to continue and meet your reporting obligations to us. The brief that we had to our developers was to say that, assume these agencies know nothing about the law or their legal obligation. All they know is what's happened. So we need to have a tool that converts that into information about their legal obligation. I mean, I and many others have been a bit worried about this mandatory breach thing because it's not 100% clear where the threshold is. And if you've got a lawyer telling you, hey, you better err on the side of disclosure, because otherwise you could get a $10,000 fine, you know, the cumulative effect of that could be actually counterproductive. It could be undermining confidence in your organization and creating anxiety among your customers. If every time a near miss occurs, you sort of bring the klaxon and mea culpa. I do think it's a singular opportunity. You know, we haven't had a new Privacy Act for 27 years, so let's grab that opportunity and just seize the moment to raise the level of practice in your organization. I've got some resources that I'm going to show you in a minute, but I mean, a general raising of awareness would be valuable and important. Your CEO and chairman will support you because it's new. You don't have to tell them that mostly it's the same as it ever was. But, you know, seize the moment in the way that health and safety became the issue of the moment when the new legislation came in a few years ago, right? Grab that opportunity to make sure everyone upgrades their awareness and so on. Look at your privacy statement. Think about where your information is going and things. If you need help, we've got loads of resources. Register for our newsletter on our website. You'll get links to these blog posts and the like. And we also have developed this sort of frequently asked questions tool, which is constantly being upgraded and added to capture developing issues. And it tells us what's going on out there in the community because we see the questions people are asking. You know, everybody wants to record each other. That's what I get from this. So that's called Ask Us. It just sits on our website. But for preparing for Privacy Act 2020, if you're reasonably well informed about how privacy worked already, then jump on and do Privacy Act 2020. That'll just embed some of the material that I've given you today. If you want to really just have that most basic level of awareness raising in your organization, go onto our website, online resources, find a link to Privacy ABC, and just say everybody in the organization has to do this. It only takes 20 minutes. It's really non-technical. It doesn't mention a section of the Act. You don't have to be a lawyer. It's really designed for the receptionist in your organization, you know, so that he or she is thinking about the importance of privacy and the significance of you being entrusted with people's personal information. It's designed for the person that you expect to print out that correspondence and put it in an envelope and send it out to make sure that when he or she gets it from the printer, there's not two letters there, right? That sort of thing, the email. So I do commend that to you. If you want a deeper dive, get your privacy officer to do Privacy 101. That's a little bit more technical, still pretty basic. We thought it was basic, but we were told it was a bit technical. And again, the privacy breach reporting module is there too. We have a privacy trust mark. So if you reckon you're really going above and beyond in terms of the way you treat personal information in a particular product or service, you might want to think about getting that. We awarded it to a app developer who produced a contact tracing, no, was it contact tracing? Registration, visitor registration app called Ripple. And it was very much designed with privacy in mind, but also meeting those, obviously it had to meet the health regulatory requirements for pandemic management, but also do that in a way that's really protective of privacy. So we were pleased to award that with a privacy trust mark. They then went on to the UK market and were able to get a quite considerable advantage on some of their competitors because they had that privacy trust mark, which links back to our website and says that it's highly compliant. So look, I'll pause there and have a look at the Q&A. I might unshare my screen so we can see each other. And I have a couple of questions. How do you determine if overseas information is adequately protected, i.e. Google Drive, OneDrive, Dropbox, Xero are all based offshore? How do I make sure I have complied? So that's a good question. The new principle which restricts the flow of information overseas does not apply where the agency you're giving it to is purely handling that on your behalf as a processor. And most of those examples that you've given, they don't look at the information, they don't monetize it. They are simply holding it for you and then delivering it back to you, or organizing it for you, or processing it for you. But they're not doing something by them, with it on their own. There's no separate business imperative. So that wouldn't apply. Similarly, my whole office infrastructure is hosted on Microsoft Azure out of Sydney. I don't treat that as a disclosure to that company. It's not. It's in law. It's deemed as being constantly held by me. I remain responsible for that. So if one of those companies has a breach, I'll hold you responsible, and it will be on you to recover from them if they have not met the expected standard. Richard Hogan asks, do overseas-based service providers include organizations for cloud storage? Yeah, that's the point that I've just covered. So, we've got a relatively small audience today. So, if anybody wants to, do we have the raise hand function? I think we do. If you want to,
We should do.
or maybe we don't. But just
John,
jump on and.
I've got one more question for you, John.
Sure.
When somebody comes to you and wants their information played back to them, can they recover? Can the organizer or the agent recover any costs for doing that work?
A private sector agency that is not a health agency and not a credit reporter can charge a reasonable fee for providing information. But there is what's reasonable will depend on the circumstances. So, and it's one of the few powers that I have to enforce this law that I'm able to actually set a fee, a reasonable price. So I can give you one example from reasonably recently. A man was in dispute with his lawyer, and he asked for all his personal information, which included client files going back some years. The lawyer said, well, there's about 7 gigabytes worth of stuff. And no, what did he say? 3 gigabytes, I can't remember what it was. And to copy it all out, it's going to cost $19,000, which happened to be reasonably close to the level of fees that were in dispute. I investigated and sent someone down to Warehouse Stationery and found that the cost of a USB stick sufficient to hold all that information was $7.99. So I fixed the price, the reasonable charge for providing that information at $7.99.
Any other questions out there? If you've got something, we'll certainly take the opportunity to have that answered. Maybe another one from me, John. You mentioned that email is the biggest area of breach that's experienced at the moment. What is the most common fault, if you want to call it, that you observe with businesses breaching their privacy in email?
Well, a very common one that we've all seen, and many of us have done, is using the CC field rather than the BCC field, right? So you're disclosing everybody's email. Now, that's not a privacy breach if you're, I don't know, the Remarkable Ski Field emailing members to say, hey, looks like we've had a big dump of snow, we're going to put an extra day on, because who cares, right? It's not going to cause any harm. But if you're the addiction service and you email all your clients that changing your opening hours, and you use the CC field, and that is disclosing more than just the email address. It's disclosing that they have some relationship with that sensitive health service. We see autocomplete, careless autocomplete. I got an email a couple of years ago from the Law Society, and it was offering mentoring opportunities for young women lawyers. And I thought, oh, great, I got one of them. Young Elizabeth, she might be interested in this. So I forwarded that email to her. My email auto-completed, I hit send. And my colleague, who's the Information Commissioner from the United Kingdom, Elizabeth Denham, was quite surprised to find that I was recommending that she might benefit from mentoring from women lawyers in Wellington. So, there's that kind of thing as well. But again, that one wasn't particularly sensitive. The attaching of spreadsheets. If the more information you're going to send out, the more diligent you have to be, because there's one golden rule. When you send out that email of sensitive client information and you get it wrong, it's going to go to the person who's got the biggest axe to grind with you, to the one who's really got a grievance. There's many cases of this. There's the one I like to use from Queenstown. I hope it's not apocryphal, because I'll be doing the council a disservice, but it was reported a few years ago that somebody rang Queenstown Lakes District Council and said, I want to make a complaint. The receptionist said, yeah, sure, well, you have to use our form. He said, can you email me the form? The telephonist said, sure. She drags and drops the entire complaints database and emails it to this guy. So it has lists of hundreds of complainants, people complained against, and the matters that were the subject of those complaints. The EQC, a few years ago, sent a spreadsheet that had what's called a pivot table in it, that had the details of 80,000 insurance claims. And they sent it to the one guy who was a disgruntled former employee who'd set up a whole lobby group, an anti-EQC lobby group. So, again, he would use that to further his campaign against that organization. So, when you see these things, take the opportunity to think, okay, so no one was harmed in this one, but what can we learn from it? Why did someone send me a spreadsheet with 3,000 names in it? I'm a manager, I don't need to know those names. And what messages can you send out to staff about if you're going to send, if you really do need to send a spreadsheet with a whole lot of personal information in it, can you password protect it? That kind of thing.
Okay, great. There's a few more questions popped up there now. We've got one from Erna.
Oh, okay.
If an employer responds to another employer's queries about a past employee's performance, are you breaching that past employee's privacy?
Well, you could, and most people will nominate. The practice should be that if you want to approach referees, you should ask for the person's permission. So they will nominate some referees. If you think, if you're looking at it and you say, okay, you've given me 3 referees, none of them are your previous employer, I think you need first to take that up with the candidate and get their permission. That means when you ask the other candidate, so when you ask the previous employer, you can say they have authorized you to disclose this to me. So that's really important. It also gives the individual a bit of control. So they can say to you, actually, the reason I didn't give my current employer as a referee is that, I was really, I had this terrible experience of sexual harassment with them, and so that's going to color their view. So if you speak to them, that's what, just bear that in mind. And then you can weigh that up. Or the person might say, well, no, and I feel sufficiently strongly about it that I don't want to proceed with this application. So yeah, I think when it comes to references, it's always best to ensure that you have the permission of the individual before making the inquiry.
Great, thank you. Another one here, sports clubs are often asked to provide members' information to the parent body. Is that okay, and should you get explicit consent first?
Yeah, I mean, again, this goes back to the conversation we had about your privacy statement. So that sports club should, it's not strictly speaking consent in the strict legal sense. You tell them. I used to talk about when I was in practice, say, don't ask them, tell them. If you belong to the sports club, here's what happens. So it goes to the NZRFU or Swimming New Zealand or whatever it is. If you ask them, then you've got to actually be prepared for them to say no. And if it's always, you know, if it has to because of your funding or your governance arrangements, just make sure that people are aware of that. It has to go to that overarching body. So tell people why. So that should be in your privacy statement, for example. If that person is in a sports club and you want to have a look at your compliance, go to our website and find a device called Privomatic. It's a little widget which allows you to enter a bit of information about your organization, say where the information goes, and then it produces a statement that you can put on your website or in your brochures or in your membership pack or whatever it is.
All right, thank you. Got one last question here. Might be reasonably general, but it'd be interesting to get your view. So the question is, what is the general use for the data that people are hacking from communications that aren't secure? Is there sort of a general trend?
It's a really hard question to answer, unfortunately, because you know, those people who access and use that don't often advertise the fact that there are marketplaces in hacked data. You can obtain lists on the dark web. Email addresses can be taken over and used for DDoS attacks. Identity credentials can be used to access credit applications. You know, sometimes there are credit card details that can be used for fraudulent transactions and the like. So it's, yeah, I guess it's limited by the fraudster's imagination to a certain extent. I mean, there was the Ashley Madison hack, where there was some of that information was going to be used for blackmail purposes.
Right. Well, John, I think we've got most of we've got all the questions answered. Thank you very much. I'd like to thank you for the time this afternoon. It's great information. I think the key takeaway from me really is, and we're a pretty small organisation, and we're certainly going to take up some of those recommendations as the chamber. Around, you know, your Privomatic, we'll have a look at that, and the e-learning modules that you've got there. The piece that I'll really take away though is that we want to use those tools really in our organisations to foster that culture of a respect for privacy. So rather than make it a compliance thing, it's just a respectful thing around, you know, people's information. So I think bringing all of that into conversation around the office, around your workplace, will really help people understand the importance of privacy. So that's certainly something that we'll be doing in the chamber organisation, and also encouraging our members and supporting them to do that. Again, thank you for your guidance today, and we look forward to welcoming you back to Queenstown somewhere around the 17th. Not expecting a snow day on November 17th, but it's not happened before, so anything can happen. But really appreciate your time today. Thanks, John.
Thanks, Craig. Thanks, everyone.
Yes.